So my name is Michael Sfard, and I'm an Israeli born lawyer. I was born to a family that came to Israel. My parents came in 1968 from Warsaw after the student uprising in March of '68. My father was in prison in Warsaw for several months for his political activities. My mother's father was a professor at Warsaw University and was fired, and the regime there that wanted to incite the public against the protesters, against the students, tried to dub the protests as a Jewish conspiracy. And they took, all the names of the Jewish leaders, and there were several Jewish leaders among the student union members, and to show that that this is actually a Zionist conspiracy or something like that. So my parents, though not born Zionists, were coerced by the regime to leave, basically, and they were deported with their families, and that's why I was born here. And I was born here in a country where my parents constantly told me that no matter how critical you are, you should know it can get worse. And there are much worse things than what you see around you in Israel. And you should remember that it's a big thing that you can say out loud your criticism. Because where we came from, you would go to prison for saying things like that. And I always said to my parents, I don't have to say thank you for being able to say what I think. And the fact that you lived in this shitty regime doesn't mean that I have to be thankful for the flaws of my country. Well, I'm telling you all this because when I have my conversations with my parents today, they agree that they completed a circle in their lives. They came from one regime that completely was undemocratic, and now they're living in a place that is getting to become as undemocratic and as authoritarian as the place where they came from. So this was my opening to start to talk about the occupation and about how it affects the Israeli reality. And when we talk, and I'm a lawyer, as I was introduced. I'm a lawyer. My expertise is international law. And when we talk about occupation and when we talk about the areas that Israel has occupied in 1967, there are many dates where a presentation about this, a legal presentation, can start. We can start in '67. We can start at '48. We can start 2,000 years ago. And of course, the choice when to start the presentation is a very political one. It also has a political meaning. I'll start in 1945. What happened in 1945? The end of the Second World War. What also happened in 1945? As the war ended depending on if you ask the Soviets or the Americans, in the 8th or the 9th of May of 1945. Sorry? And in June, only a month after the surrender of the Nazis, in San Francisco, an international conference was convened, and 50 states sent delegations. And in June, we're on the ashes of the Second World War, the worst war humanity has ever known. A new international organization was created, the United Nations. In the statute, like the constitution of that new international organization, which was supposed, like its predecessor, the League of Nations. The League of Nations was created after the First World War, with the idea that we need an international organization that will keep the peace and security in the world. And the League of Nations, I don't think there is any entity in the world that failed so miserably as the League of Nations. The League of Nations led us to the Second World War. So the United Nations, they didn't just change the name, they had created a new constitution. It's called the UN Charter. And the UN Charter had in it a revolutionary legal concept, a concept that has never been a legal norm in international law. Before we'll talk about that novelty, I want to say something about what is international law. So we all know to various degrees what law means. Law are a set of rules, norms that coordinate and dictate what entities, subjects of the law, subject could be people, of course, legal people like corporations, states, institutions, what are their rights, what are their obligations, what are their powers, okay? So the law is a system of rules and norms that regulates behavior and powers and relationships. And this is how every law is. Israeli law, American law, Russian law, French law. All systems of law deal with these issues. They have subjects. Subjects are people, human beings. Subjects are corporations. Subjects can be public institutions, the state. Unfortunately, animals are not yet subjects of the law, but it will be one day when people will realize that animals are also a creation of God. But we'll put it aside. So international law is the same. It's a set of norms and rules. But it's not about the subjects of international law are states. And today, it's also correct to say also human beings, not only states. International law regulates what is permissible and what is prohibited. What are the relationships between states, between nations, and also between nations and their subjects, their citizens. That's human rights law. What can a state do to its subjects? International law, just like any other legal system, has many fields. So if we talk about Israeli law, we have criminal law, we have contract law, we have tax law, we have copyright law. We have all kinds of fields that regulate different types of issues and relationships between people and between people and people and between people and the state. International law is the same. It has many fields. International law regulates different types of issues. There is international tax law. There is international copyright law. You know, how can we make China not copy music and just sell it without paying royalties, for example? So international law comes into play. We have diplomacy law. Why do diplomats, what are the immunities of diplomats and ambassadors, right? And how do states conduct their relationship? What is permissible and what not, and so on. So there are many fields in international law. International law is not a new concept. To some degree, we have international law in biblical times. We have international law definitely in Hellenic times. And we can see that sometimes in TV series, you know, the TV series that depict ancient era. And you see that there are rules, even to the war, what is allowed to do and what is not, and how it is not permissible to kill, to murder the courier that came with an offer, right, from the other side, and so on. So international law is not a new concept. And probably the most ancient field of international law are the laws of war. Humanity has made a choice that war is not a lawless event. We could have decided that if there is law, everything is permissible. But we as a race, the human race, have made an ethical choice, and we've decided no. Even when there is war, there are things that cannot be done. And the things that are not allowed to be done, and the type of actions that are prohibited as a means of warfare are different from, you know, in biblical times and today, and we'll get to that. And then there is the question of what makes a war legal, okay? When is it allowed to use force? And now I'm going back to the UN Charter. The UN Charter had in the San Francisco conference, the states that convened on the ashes of the Second World War have adopted a revolutionary idea that for you will sound banal, because you are all, me including, creatures of the post-Second World War era. And the concept is that use of force in international relations is prohibited. And if I would have this talk 100 years ago, people would react completely differently to what I'm saying now. Because you have to understand that for thousands of years, nations had in their toolbox many tools in which they were allowed to use to pursue their interests. Their economic might, their cultural might, their political powers, and their military powers. All of these were legitimate in order to pursue the interests of the nation. So if I know that on the other side of the border, in the neighboring state, there was revealed that there is an oil field, and I want that field, I can use my economic powers, my economic advantage, to coerce the state to sell it to me in very low price. I can use my political power, if I have a political power, in order to create such a pressure on this other state to come to terms with me, to divide the oil field. Or I can invade and take by force this field of oil field. 100 years ago, that was the banal thing to say, because all of these were considered legitimate ways of conducting international relations. In 1945, for the first time in human history, the military tool was taken out of the toolbox of nations and states. All the wars that we had since, if you ask those who started the wars, were wars of self-defense, right? Ask Saddam Hussein, well, you can't ask him, but if we could ask him why he invaded Kuwait, he would say Kuwait was posing a huge danger on me. I don't have to tell you that both the invasion to Crimea and the invasion to the other parts of Ukraine were and still are portrayed by Putin as wars of self-defense. They were engaging in a genocide against the Russians of Ukraine, not less than that. All the wars that Israel has ever had were wars of self-defense. There's not a single war and a single leader that was an aggressor and didn't try to brand his aggression as a war of self-defense, because the prohibition on the use of force has an exception, and the exception is self-defense. So it's clear for us that there is a problem with using force without any reason. That's what I was trying to say. Not that of course, wars kept on going after the creation of the United Nations. And America went to wars all around the world to beat the Soviets. They always said, well, we were called to help in collective self-defense. So that idea that use of force is not a legitimate way to conduct international relations was and is a novelty. And in order to cement that idea, that prohibition, there are several other norms that were created, legal norms, that were meant to stabilize the prohibition on use of force. One is the crime of aggression. The crime of aggression is part of international criminal law. There is a field that deals with international crimes. And one of the four categories of international crimes, the four categories are war crimes, crimes against humanity, genocide, which is a category of itself, and the crime of aggression, or a crime against the peace. Crime of aggression is when using force not in self-defense, illegally. And Nazi generals and Nazi leaders and Japanese generals and leaders were put to trial in Nuremberg and in Tokyo trials after the Second World War for the crime of aggression, for the crime against the peace, for going to war. Okay? So that's one way to make this prohibition on use of force stronger. There is a second and even more important norm that is meant to make sure that nations would not embark on wars of aggression. And that is the prohibition on annexing occupied territory. Annexation of a territory that was occupied by force means that the state that occupied, let's assume there was a war, we'll decide the question of whether it was a legal war, war of self-defense, or was it an illegal war, war of aggression. But in that war, during that war, one of the armies conquered a territory of the other, of the adversary. So there is an occupied territory. Annexing that territory, making it part of your sovereign territory, if that is permissible, if that is allowed, if that is legitimized, then you incentivize leaders to go on wars of aggression. There is a good reason to go on war, portray it as a war of self-defense, when actually the intention is to occupy land. And in that land there are many things. There are natural resources and there are things that might be worth a lot. So the prohibition on annexation of occupied territory is a major norm, rule of the post-Second World War international rule-based order that is meant to make sure that countries do not, and leaders do not have the incentive to go on wars of aggression. Okay? It's very important to understand that. No one, in creating these norms, thought of Israel. No one thought of Judea and Samaria or the West Bank or East Jerusalem. Those people who convened in San Francisco in June of 1945, before the State of Israel even was created, were thinking of eradicating wars. They are immediately after the trauma of 6 years of the Second World War, 65 to 70 million casualties, with the most horrific genocide humanity has ever saw, with atrocities and war crimes in a scale never seen before. What they had in mind is, how do we make sure that we at least aspire to eradicate the wars? And that is the mechanism they chose. To delegitimize and outlaw the use of force that is not in self-defense, and to prohibit annexation or the creation of sovereignty over territory by force. So when we talk about the laws of occupation, we need to remember this. We need to remember that that's the pond, the normative, ethical, moral, legal pond from which the modern laws of occupation were created. The laws of occupation are part of the laws of war. The laws of war have two subfields, the international laws of war. One is the laws that deal with the legality of use of force. What we talked about up till now. When is it allowed to use force? What is considered to be self-defense? What is considered to be collective self-defense? What is considered to be in humanitarian intervention? Okay? Can I use force in order to save? I'm not being attacked. I don't need to defend myself. But in my neighboring country, there's a genocide going on. Can I intervene by force to stop that? So these are questions that the subfield of the laws of war that deal with the beginning of the war, or the legality of use of force. And aside, and in parallel to that, there is another subfield to the laws of war. And this is the laws of warfare. The laws of warfare ask the question, okay, there is a war. What kind of war actions are legal and what are illegal? How do you wage war? So we have the laws of use of force. The violation of those laws is the crime of aggression, the international crime of aggression. We have the laws of warfare. The violation of those laws are what we call war crimes, okay? Because this subfield of the laws of warfare, they regulate the battle. And they ask, who can you target as a combatant? Who can you target? What are legal and legitimate targets and what are illegal targets? They ask a question, what kind of weapons can you use? And are there illegal weapons that you can't use? And things of that sort, okay? So I'll give you a few examples. For example, it is not allowed to target civilian objects and civilians. It is not allowed to use starvation as a method of war. No matter what is the goal, no matter what you can achieve by starving the people, that is a war crime, using starvation as a method of war. It's not allowed to transfer population by force, not for their own safety, for temporary time, and with providing them the humanitarian assistance they need where you transfer them to. All of these are war crimes. So this is the laws of warfare. And within the laws of warfare, there is a subfield, which is a subfield of the laws of war. Yes, we have the laws of war, the laws of use of force, the laws of warfare, and within the laws of warfare, we have a subfield that is the laws of occupation. Because during the battle, during the war, there might be a reality in which one side conquers a territory of the adversary. And international law wants to regulate what goes on in that territory. The ideas that war can be legal or illegal starts in Christian thought. Christian thought. Christian thought has created the notion of wars that are justified and wars that are not justified. It's not only in Christian thought, but Christian thought is the one that influenced the secular jurists that developed this idea into the secular concept of just and unjust wars. But it originates in religion. So let me just continue with the laws of occupation. The laws of occupation, basically, they say the following. You remember that it's not allowed to annex territory? So the laws of occupation basically are based on several major principles. The first principle is that the occupation is temporary. It cannot be permanent. Because if it's permanent, it's like annexation. What does it mean that it's temporary? What is the deadline? When it has to end? The laws of occupation do not provide a calendaric deadline. What they provide is that the occupier and the international community must constantly make an effort to bring the occupation to an end. Not always you can end an occupation. Sometimes there's no way, not because of security, because you don't have a partner, because whatever. But you have to, it's an obligation of the occupier to constantly look for ways to end the occupation. And ending the occupation can be done by an agreement with the sovereign. The sovereign in modern times is the people. So they're representatives of those who you occupy. If they are ready to become part of your country and get citizenship, then annexation is allowed. But they have to agree to that. And it's not by force. So it's temporary. Temporary not only means that you have to constantly make an effort to end it. Temporariness also means that you cannot make long-term changes to the territory because you're not the sovereign. You're not the sovereign. That means, it means there are things the occupier is supposed to manage the occupied territory, but it cannot make long-term changes. The occupier is not a sovereign. It cannot change the territory. It has to maintain it, to conserve it the way he or she found it. The second principle of the laws of war is that occupation is a system of, it's called usufruct, which means it's a trust. The occupier is managing the territory for the benefit of the occupied people. Their government is no longer in the territory. It doesn't have effective control over the territory. Their government is away. Someone needs to take care of the people. And this someone is the occupier. The occupying force needs to restore civil life, security, safety to the occupied territory and make sure that the people in the occupied territory can resume life as much as possible to normal for the duration of the occupation. Annexation means that the sovereign of the state that occupies becomes the sovereign of the occupied territory. Let's talk now in terms of Israel and the West Bank, okay? Who is the sovereign in Israel? Israeli government is chosen, is elected, right? Who is the sovereign in Israel? The people. The citizens of Israel are the sovereign. They elect representatives to the Knesset. The sovereign elects representatives. These representatives appoint a government. But the sovereign are the citizens. We are the ones who are the sovereign. Our Knesset doesn't legislate in the occupied territory. Our government doesn't rule in the occupied territory. It's our army that does. It's the army, and there is a buffer, and should be, thank you so much. And there should be thank you. You read my mind. There should be a buffer between the sovereign, because, now listen carefully, because otherwise it's an apartheid. You have people who do not vote, cannot be elected. You have people that do vote and can be elected, and they are the ones who make decisions, and they are the ones who call the shots and create the norms and write the norms over the people who do not vote and cannot be elected. So annexation means that the sovereign in the occupying state becomes also the sovereign in the occupied territory. When we have an occupation, it doesn't happen. What we do have, under international law, an occupying force that is distinct from the government. The international law doesn't care that the Israeli army receives orders from the government. In the eyes of international law, it's the Israeli army that is responsible to the West Bank, not the Israeli government. Under Israeli constitutional law, of course, the army is subject to the government. So it's a very complex situation here. But the administrative powers in the occupied territory are not of the Israeli government, but the Israeli army. Because the Israeli army is the occupier. Is the occupier's government. Is the government of the occupation. And the international laws of occupation create an authoritarian regime. They provide that all powers of government will be vested with the commander of the occupying force. There is a person. His name is Avi Balut. That's the name of this person. By the way, it's always a he. It was never a she. Maybe that's one of our problems. And this he is the legislator. If he signs an order, it's primary legislation. He doesn't need 61 votes, 3 readings in the Knesset. If he signs a piece of paper, that is a law, like in monarchies. when he is also the judiciary, and he appoints military judges, and they try the occupied people when they commit offenses. And he is, of course, also the executive branch, and his soldiers operate like police force, and they enforce the law, the military law. So you have here an authoritarian regime that was sketched by international law. When by international law, the occupied people's civil and political rights are suspended for the duration of the occupation. They do not have the right to vote. They do not have the right to be elected. They are not part, they do not have a voice in the corridors of power where their fate is being decided. That's international law. Why? In order for the occupied military to be able to effectively discharge of its duties to restore civil life, security, and normal life, temporarily, non-democratically. In places where the Israeli army has effective control, then military law applies. Usually the first proclamation of a military in an occupation, the first proclamation usually says all the laws that were enforced before I conquered will remain in place unless I change them, so that there is a continuation of legal order. So the laws of occupation create this regime that on the one hand is authoritarian, on the other hand is not sovereignty, makes sure that it's not sovereignty, and then it creates, and that's the third element or character of these laws, it creates a lot of safeguards for the rights of the occupied people. So basically the laws of occupation are like a constitution, a bill of rights for the occupied people. Because they don't have civil and political rights, they cannot defend their own rights by themselves. It's the international laws of occupation, which I didn't say, but are codified. Codified means that they were written into mainly two international treaties, the Fourth Hague Convention and the Fourth Geneva Convention. One was written in 1907, the Hague Convention, and one in 1949 after the Second World War, the Fourth Geneva Convention. And they have a lot of articles and paragraphs that deal with how an occupation should operate. And most countries of the world, including Israel, are signatories and accept those treaties as binding. So there are many rules in international laws of occupation, making sure that the army, the occupying force, will not violate the basic rights of the occupied people. Now, usually, rights are protected, but there are exceptions to the protection. Okay? You cannot violate property rights of the occupied people unless military urgent necessity demands to violate those property rights. So, for example, if an army needs to seize a roof in order, because it's strategic and they need to have soldiers in a lookout, they can do it. That's a violation of property rights, but that's an exception. So that's just an example. There are several prohibitions that do not have exceptions. Basically, the longer the occupation lasts, the more it is reasonable to expect the occupier not only to be allowed, but also to be under duty to do longer term changes, okay? So an occupier that sorry?
In the law?
In the interpretation of the law, yes. So the interpretation of international law, there are always, lawyers make money out of disagreements, so there's always different positions. But basically, there is I wouldn't say consensus, but there is a very powerful agreement that if the occupation lasts for 3 decades, you cannot not build roads, new roads. You cannot leave the occupied territory in such a backwarded condition when it comes to infrastructure. So if in the first year of occupation it would seem unreasonable, illegal for an occupation regime to start huge projects of construction, in the third decade it would seem more legal. the occupied people are the sovereign. They are the sovereign, but their sovereignty is at the moment suspended because there is effective control over them by a foreign power. Right. So the sovereign is waiting to implement its sovereignty. At the moment, it cannot do that. If I will allow them to do that, if I will provide them with control over their own territory, occupation ends. That's the end of occupation. That's a happy end. The question I'm asking is what is permissible and what not for an occupation regime that is still clinging to the territory? That's the question. And as I said, there are some duties, obligations that international law imposes on the occupier. It provides the occupying power with a lot of, the occupying force, with a lot of powers, right? Because as I said, it's the legislator, he is the legislator, the executive, and the judiciary. And then there are prohibitions, some of them with exceptions, and some of them without exceptions. And I want to highlight one set of prohibitions that is extremely important and has no exception. And that is the prohibition on demographic engineering of the occupied territory. One of the insights that humanity had analyzing Second World War was that one of the worst things, this phrase you will not find in international law. In a moment I'll use the phrases used in international law, but I collect them under the heading demographic engineering. One of the things that made wars and conflicts, international conflicts, so difficult to solve and peace to be restored was when the opposing parties started moving people from one place to another, whole communities, transferring people by force, deporting people from one place to another. In the Second World War, there were many of these. You know, the German wanted to Germanize parts of Poland. The Russians, the Soviets wanted to settle some other, the Baltics, with Russian people. There was constantly moving of communities, of tribes, of ethnic minorities from one place to another. 1949, the Fourth Geneva Convention, has an extremely important paragraph. It's paragraph 49. This paragraph has 6 sentences. The first prohibits any kind of population transfer of occupied people. Transfer or deportation. Transfer means moving people coercively from one place to another within the occupied territory. From one place to another. From Khan el-Ahmar to Ramallah. From Asaf-Ariata to Yatta. That would be population transfer. From the north of the Gaza Strip to the humanitarian city in Orwellian newspeak in the southern tip of Gaza. These are population transfers. When you evacuate coercively people, either by loading them on trucks at a gunpoint, or by creating coercive measures that would make them run away, leave because they don't really have a choice. These are population transfers. Just to end this, transfer is within the territory. Deportations are out of the territory, to deport people beyond the border. Now you're talking to a lawyer that is representing Arakib. Yes. And in Arakib, our argument was that they were forcibly transferred in order to take away their lands. And we had a historian, Gadi El-Ghazi, who gave us a very powerful expert opinion that proved that Moshe Dayan, back then, gave an order to deport them in order to take away their lands because they lived in the northern part of the Negev, which has richer soil. Yeah, that's called transfer. When it's outside the border, it's called deportation. Okay? The Nakba was both. The Nakba had a deportation part, which was to drive people either by making them flee or by actually pushing them by force outside the border, and population transfer within. Both of these things are international crimes. When they are committed in times of war, they are war crimes. When they are committed on a large scale, they are considered even a worse type of crime, which is called the crime against humanity. Okay? What is happening in Gaza today, for me, and I'm only talking now about the aspect of population transfer, is definitely a crime against humanity. Now, that's Article 1 that's the first paragraph of Article 49. It's not a zero-sum game. If one party commits a crime, it doesn't allow the other party to commit a crime. And only consensual, but really consensual, movement of people is not criminal. And I have to say that I don't know, it's theoretical. There is no such thing. People do not move unless, people move on a small scale. They relocate because they have a job or family or friends or whatever. But people do not move. Whole communities do not decide to leave where they reside. So the fact that there was a population swap doesn't make it legal. Also happened in a huge scale in India, Pakistan, in the war that created the partition.
So in this situation, both committed
Yeah.
crimes.
Yeah. Okay, so that was the first. That was the first paragraph of Article 49, which prohibits moving by forcibly, the occupied people. But then you have another part of Article 49, which prohibits what? The other side of the coin of demographic engineering. Not moving the people the indigenous people of the occupied territory, but moving people into the occupied territory. Changing the demography by settling the occupied territory, by transferring your own population into the occupied territory. Now, very smartly, the international law, or the Article 49, doesn't demand that this transfer on that direction will be forcible. It is just not permissible to create the system that would allow people from the occupying state to immigrate and move into the occupied territory. It is prohibited to create settlements. These two prohibitions, the prohibition on transferring and deporting people from the occupied territory, and the prohibition on transferring people into the occupied territory, are meant to make sure that the occupying state, the occupying force, would not change the demography of the occupied territory, creating a situation that is very complex to solve, and there are no better people that know that than us. So first of all, apartheid is an international crime. It's a crime against humanity. It's the more elevated type of crimes, one of the 17 crimes against humanity. And it is a crime that deals with inhumane acts that are committed in a context of an institutionalized regime that discriminates and oppresses a group of people. So when there is one group that systematically discriminates and oppresses another group, that is considered apartheid. With an aim to maintain, to perpetuate, to make this kind of regime permanent. And when I mentioned apartheid here before, I mentioned it in the context of an occupation, annexation that would not confer civil rights to the occupied people. Because then you have one state with people who have rights and those who do not have rights. But we did something else. We moved our own people, our citizens, into the occupied territory, creating a reality in which in one area there are two communities. One is a community of Israelis, hundreds of thousands of them, who have civil and political rights, who have the right to vote and to be elected. And you have a community of millions who do not, who are their neighbors. So I was mainly talking about the West Bank, but if we're getting into East Jerusalem, they do not have the right to vote. They do not have the right to vote. They were not provided with Israeli citizenship. Instead, they were provided with, when Israel annexed East Jerusalem illegally, because now you know that it's illegal to annex occupied territory unilaterally. And so no country in the world, including Trump's America, does not recognize the annexation of East Jerusalem. No country in the world. However, the hundreds of thousands of Palestinians living in East Jerusalem have received a status of permanent residents, not citizens, with some kind of a route to ask for citizenship. There are 300,000 more, 350,000 East Jerusalemites, and about 15,000 who have Israeli citizenship. So it's not really an option. Most of them do not want to ask for citizenship because they do not feel that they are Israeli, they are Palestinians. Golan Heights, most of the people that lived in the Golan Heights, the Syrians, we have deported. People don't know that. There was a whole city called Quneitra that was completely deported. The small amount of Syrian nationals that were living, that remained in the Golan Heights, were offered Israeli citizenship. Many of them refused until today, and they are permanent residents. Some of them did accept. Sorry? Laissez-passer. So this is why settlements are illegal. Settlements are illegal in order to eradicate wars. This is as important as that. It's not something small. It's not a political interest. Every Israeli that moves into a settlement is harming humanity's desire to eradicate wars. You get that? That's the line. That's why it's so important. And that is why our international community that has such a horrible record in applying international law evenly to all, very bad record. When it comes to the prohibition on annexation, its record is quite good. But let's first understand what the law says. And when you look at the prohibition on annexation of occupied territory, which is new in international law, from 1945, 46, 47, 49, one of the only areas in which you can see quite a good record. The international community has not recognized the annexation of East Jerusalem or the Golan Heights. It did not recognize the annexation of Western Sahara by Morocco. It did not recognize the annexation of Crimea by Russia. Actually, big parts of the international community has imposed sanctions on many, many Russians, leaders and officials, because of that annexation. And the same when it comes to the areas in mainland Ukraine that were annexed. So we can see that there is a pattern here in which annexation of territory occupied by force is not recognized. And even the northern Cyprus, which is not, it's a puppet state of Turkey, is not recognized as an independent state. It is seen as an illegal annexation. And that is important. It is important. And one of the problems Israel faces when it works its way to annex the West Bank is not the rights of Palestinians. It's the fact that if Israel gets away with it, rightly Putin will ask why Israel is allowed to and I don't, and I'm not. Why am I under sanctions and Netanyahu can get away with annexation? And the idea that, that law in general has to operate evenly, otherwise it is seen arbitrary and unjust, is very important in this sense. Jerusalem was annexed. So when it was annexed, Israeli law was applied to it. But in the West Bank, yes, it's not only Jordanian. You know, as a lawyer that represents many Palestinian communities, and sometimes in land cases and things of that sort, I need to excavate, like our legal archaeology, because we have international law, of course. We have military law. We have Jordanian law. We have British law from the Mandate. And we have Ottoman law that was not revoked. So all of these laws, some bits and pieces of Ottoman law are still in force. And pieces of mandatory British law are still in force. And of course, Jordanian law that was not cancelled by the military law. And military law, and above all that, international law. I once looked through the Geneva Convention. There are 160 articles. I think 140 we have violated throughout the 6 decades of the Israeli occupation. We have done everything possible to change completely the landscape, to demographically engineer it and change it completely. We have disinherited people from their property. We grabbed their lands, not for military purposes, but for our settlement project. And we have coerced people to move and transferred them from area to area. We are pushing them into their urban enclaves in order to make room in the open areas for further Jewish development. We're curbing Palestinian presence everywhere that is not in the center of the urban areas. And we have applied different laws to our citizens, to Jews that live there, through channeling Israeli law by the military commander orders to apply them. So for example, if 2 individuals commit the same crime in the West Bank, let's say an Israeli settler and a Palestinian, both kill their neighbor for reasons that have nothing to do with the conflict. And they commit the crime of manslaughter, okay? The Israeli will be arrested by the Israeli police. And within 24 hours, according to Israeli law, that applies to all of us when we go to the occupied territory, we are going there with a bubble of Israeli law. So within 24 hours, we'll have to be brought before a magistrate court judge, Shofet Shalom. And that magistrate court judge will have the power to extend the detention by 15 days maximum, and altogether by 30 days if he is extended several times. And after that, he will be indicted for manslaughter in the Jerusalem District Court before a civil court judge, civilian, and will face up to 20 years imprisonment, which is the maximum penalty for manslaughter, not murder. His neighbor, the Palestinian, will be arrested by the army, will be held for up to 96 hours, not 24, and then be brought before a military court judge who can extend his detention by 30 days, up to 90 days altogether. And if indicted, he will face life imprisonment and will be tried by a military court in a language that is not his language, and so on. And you know what they say about military law. That military law to law is like military music to music. Well, in fact, if it's not done with a gun, by a knife, it will not be of interest to Israel, and they will hand him over to the Palestinian police. If it is considered to be a crime that is of security element, then Israel will. If it happens in Area A, most likely, if it's not of interest to Israel, we will not jeopardize our troops to get hold of this person. But if it has to do with security, then yes, definitely we'll go and apprehend him. Law. Law in general, modern law, one of the features of modern law is that it is territorial and not personal, okay? In antiquities, law, which we talked about in what is law? Set of norms, we talked about it. Set of rules, confers rights, imposes duties, provides powers, regulates conduct and behavior. Law in antiquity was personal. What does it mean it was personal? The content of the law that applies to you depends on who you are. A man or a woman, Muslim or Jewish or Christian, black or white. Okay? Different identity, different law. That's the law of antiquity. Since the French Revolution, we have the idea of equal protection of the laws. That phrase comes from the American Bill of Rights. Okay? It means that the legislator legislate norms that apply to anyone in a certain territory, in its jurisdiction. That's why when you go to Amsterdam, you can buy grass and small grass, because in that territory it is legal. Something that here would be illegal. What we have done in the occupied territory is bring back the law of antiquity. The model that says, depending on who you are, the content of the law will prevail. That kind of distinction is quite remarkable. The distinction between citizens and non-citizens is very, very limited in rights that are relevant to citizens and others do not have. But for example, criminal law is the same if you're a tourist or if you're a citizen. Has to be the same. Of course. A contract law is the same. It doesn't matter if you are an Israeli national or a businessman that came from Russia. If you sign the contract and you'll have a litigation on contracts, it doesn't matter if you're a citizen or not. Same thing about every other. The fact that you're a citizen gives you some rights that non-citizens do not have. That's for sure. But when we talk about, that's between you and your government, right? When we talk about the occupied territory, you're not governed by your government. You're governed by the occupying force, which should be neutral. Your citizenship should not make any difference to them. In fact, it should be the opposite. Because international law makes it an obligation on the occupying power, on the occupying force, and the occupying commander to look after the occupied people and their well-being. That's their obligation. You are foreign to the occupied territory. You're not supposed to be there. You're a settler. It's illegal for you to be there. Your presence is illegal. So international law would never accept that the distinction is that the justification for the distinction is you being a citizen and them not being citizens. By the way, that was exactly the argument made by apartheid South Africa. They said we're not at a certain, at first they had an official apartheid. They said blacks are second class, they don't have rights, they're less developed, whites do. Then when the movement against apartheid became so strong, then they said, you know what? Actually, it's not that they are second-class citizens. They're not citizens. We will provide them with citizenship in free states, they called it, known as Bantustans. And they will have their citizenship in those states. So now you cannot say that I'm discriminating against blacks. I'm discriminating against people who are not citizens of South Africa. For some reason, all the citizens are whites, and those who are not, all the blacks are not citizens. Israel is trying to do the same with saying, well, they are citizens of the PA. PA is like a Bantustan. Nothing is similar. Because there are different contexts and different routes to the conflict and the different, but if you ask me whether the crime of apartheid, look, apartheid has a specific root and a specific generic example in history, but it became an international crime. Once it became an international crime and has a definition, you don't have to replicate the exact type of regime that was in South Africa in order to commit the crime. If you're asking me, do we commit the crime of apartheid? My answer is absolutely yes. No question about it. It is a bit different. In some ways, it's worse than the South African apartheid. In some ways, it's less. It's different. I'll not get into this because it's a long conversation. But in general, the idea that all the resources are tilted and are allocated to one group, one race, on the expense of the other, that was the grand apartheid. And that is happening here too, unquestionably. There are arguments that in Israel proper, there is an apartheid against Palestinian minority of citizens in Israel. It's a much, much more difficult case to make. I call the Israeli, if it's not the topic of our conversation, but of course, one cannot ignore the fact that the Israeli governance system in Israel, in the 1948 borders, in the Green Line, has a lot of policies and practices and norms that makes sure that Jewish hegemony will remain, that centers of power will remain at the hands of the Jewish sector. So while Palestinian citizens of Israel enjoy the right to vote and enjoy the right to be elected, and we have a Supreme Court judge that is Palestinian with Israeli nationality, and by law there are no different laws for Jews and non-Jews in Israel, except in certain areas, small areas. There are a lot of social structures that are in place to maintain Jewish superiority. I don't think it amounts to apartheid by itself. I think there is a different concept that is suitable for this case, which a very good friend of mine, the geographer, historian, Professor Or Niftach-El, coined, and that concept is called ethnocracy. Ethnocracy means something that looks like a democracy, but has a system to maintain superiority of one ethnic group over the others. And I think that captures what we have internally in Israel. We have political system, we have a political system that makes sure that the Palestinian representatives will always be illegitimate and never have their share in the power structure in Israel. So Oslo Accord is not international. Oslo Accord is a bilateral agreement between Israel and the PLO. It was supposed to be an interim agreement for 4 years, between 1995 and 1999. And then came Netanyahu. And just like with the agreement with on the release of the hostages, which he didn't continue but violated the agreement, so he did with the Oslo Accords. So the Oslo Accords were supposed to be for 4 years. And then after those 4 years, there was supposed to be a final stage agreement, which would decide what would be the permanent situation. For those 4 years, Israel and the PLO have agreed that the West Bank will be divided into 3 categories, A, B, and C. Those are categories that determine only which authorities are governing those territories. Not whose land is it. Not whose land is it. Area A is an area, only the inner urban cities, where the PA is responsible for the civilian affairs, the Palestinian Authority, and also responsible for law and order. Security is Israel, also in Area A, because it's occupied territory. Occupation didn't end. Now, wait. Oslo Accords didn't talk about a state. The word state or Palestinian state is not mentioned in the Oslo Accords. It was widely accepted that the Oslo process would probably lead to a state. But the Oslo Agreement created an autonomy, not a state. And didn't promise a state at the end. Okay? The war in 1948 was on the backdrop of an international community decision of partition with a certain map. So you have to fine-tune your question, and I'll find it for you, fine-tune it for you. The question is not whether the newly established Israeli state in all of its territory should be considered an occupied territory, but rather whether the areas beyond the borders that the UN has allocated for the Jewish state, whether these territories are occupied territory. And the answer to that is in historical documents of young Israel. The young state of Israel called all the territories that during the war were captured beyond the borders of partition occupied territories. That's how they called it when at first. Eventually, they stopped calling it occupied territories. And until the International Court of Justice in The Hague has ruled in 2004 that the sovereign borders of Israel is the green line, there were still many jurists that said that, that all the territory that Israel has conquered beyond the borders of the plan of partition is occupied territory. But that's no longer the situation today. So, what is a state in international law is a question of law. And international law defines a state as an international entity that meets 4 criteria. We'll not get into all of that, but it has to have a territory, it has to have a permanent population, it has to have effective control over that territory, and it has to be recognized as a state. So one of the parameters for an entity to be a state under international law is that the international community recognizes it as a state. So if I will convene a press conference tomorrow here in the Beit Hasagol, and I will declare that I'm establishing a new state. It's called the Mikveh Israel Street State. Probably no one will recognize that state. And so even before talking about the other parameters, it will not be a state under international law. Israel has declared itself, not in Mikveh Israel, but in Sderot Rothschild, not far away from here. In Sderot Rothschild, I think 19. I don't remember the exact number of the house. And many states recognized it. And so did the Palestinian Authority. It declared itself as a state. And then more than half of the countries in the world, and in next week we'll have more recognitions by Western countries. It will reach probably something like 160 recognitions out of 210, I think, countries in the world. If France and Britain will recognize the Palestinian state, that means that 4 out of 5 permanent members of the Security Council will recognize Palestine as a state. Only America does not. So recognizing it means it has a legal importance. and a legal effect. Do those states also recognize the Palestinian state at a certain border? That's an important question. Some of them do. Some of them say, we recognize the state of Palestine in the 1967 borders or the 1949 armistice lines. Some of them say, we recognize the state of Palestine without indicating what the borders are. No, it's not a state. It's not a state, and Israel argues, probably with some, probably it's right, that by declaring itself as a state, the Palestinian Authority, or the PLO, violated the Oslo Accords. Because the Oslo Accords have a clause saying that none of the parties will make any unilateral steps to change the status of the land. Now, if you ask Palestinians, they will laugh. Because for 3 decades, since the Oslo Accords began, Israel has quadrupled the number of settlers in the occupied territories, built new settlements, grabbed more land. So, as Saeb Arikat, one of the negotiators for Palestine, has said, we are negotiating a cake while the other side is eating it. So yes, the declaration of statehood was a violation of that prohibition on unilaterally changing the status of the land, but Israel is the last that can complain about that. Both sides, in their behavior, made it clear that once these 4 years ended, they continue to operate according to the Oslo Accords until this day. There is cooperation in security. The ABC division is still valid. There are many things that are done. The DCOs, the offices, there are many things that are still operating according to the Oslo Accords. So even if we sign an agreement and I rent an apartment that belongs to you, and the contract says that it's for 1 year, and that year passes, and I continue to live there, I continue to pay rent, then it means that in our behavior, we extended the contract. And in general, Israel and Palestine have extended the Oslo Accords, but violated it all the time also. Okay, thank you very much. It was nice being here.